Well, I asked and you delivered. Welcome to my new sofa where I'm going to discuss some of your situations, but of course all the while understanding that it cannot be legal advice because I don't have the opportunity to ask you all of the questions, but I can give you some general guidance based on the outline of the situation that you present to me. So as promised, and in response to my request for questions and situations to discuss and analyse, here is but the first. I'm going to keep them anonymous, and remember, it's not legal advice if this happens to be your question, but it might give some general guidance to anyone else that's in a similar position moving forward. So let's go. So the email and the outline of the situation is as follows. Hello, I've seen your videos on YouTube, which are excellent. Thank you. My partner has got himself into a situation with a private car sale. A lady we know kept recommending a vehicle her daughter was selling. So straight away, this is a private sale between two parties. My partner took it for a test drive and said he would take it with an agreement in writing to pay £200 a month, totaling £1,000. So pausing just there, the first issue that would come up and get dismissed straight away is that if it was an agreement to pay in instalments over 12 months, or let's say with interest or some other fees, or more than 12 payments and so on, then that would make it a regulated agreement, which they wouldn't be allowed to do unless they've got authorization from the FCA. In this case, this one is ruled out straight away because it's £200 per month, totaling £1,000. So clearly not more than 12 months, not more than 12 payments, and there's no indication of interest. Reading on. He signed a letter in this agreement, which I've seen, by the way, and we took it to a garage as I had a bad feeling about it. Now, pausing again, always worth taking it to a garage or getting a mechanic to come out first. The RAC, I think, from memory, do this, and they send an engineer out to give the vehicle a once-over, to give it a health check, I suppose, before you buy it. That's what I would always recommend. Reading on. The car has an MOT until March next year, and I have seen what purports to be an MOT certificate dated in March of this year, which says that it expires in March of next year. Now, just pausing once again, an MOT certificate in and of itself is only a certificate that the vehicle was safe at that moment in time. Clearly, if damage occurs afterwards and it's not roadworthy, it's not good enough to simply say, well, I have an MOT certificate, therefore it's safe on the road. That's not always the case. Reading on. Our garage said that the steering wheel is dangerous and about to go. There are many holes under the car and there's an oil leak. Within the first week, we've offered 3 times for her to take back the car and keep the first payment. She's refused. So there's presumably been an attempt at repudiation with an offer of settlement already at the value of 1 payment, 1 instalment for the vehicle, i.e. £200. We've cancelled the insurance and been offered £150 to scrap it. Just pausing again, aside from the issue between the parties, there's an added issue here with regard to the insurance. First of all, obviously it cannot be on, or certainly not used on, a road or other public place, because if it doesn't have insurance, it cannot be on a road or other public place. Furthermore, you are required to notify the DVLA if a vehicle is sawn, i.e. notified of being off-road. But parking that, pun intended, for one moment, let's read on. She said, this is the interesting bit, she said that she's contacted Trading Standards legal team and threatening to call the police. Well, again, pausing there, in reverse order, I would rule out any worry about the police because there's no sort of suggestion here that you're trying to steal the car. You're just attempting to repudiate the contract of purchase of the vehicle. So the police shouldn't really be wasting time with this. So if they do come out, I would be telling them that this is a civil matter, so politely go away. As for Trading Standards legal team, it's not really anything to do with Trading Standards because Trading Standards deal with businesses. This is a private sale. Trading Standards may advise private sellers on certain things, but ultimately they're going to say that this is a private matter, a private dispute, and to sort it out between yourselves or court if necessary. Reading on. The other point is she hasn't given us her home address on this letter. She stated her mother's address and has refused to give us her home details. I feel we've been fair in offering it back, and I 100% want it off my drive. Can you point us in the right direction? So I've seen the contract of sale as well, which is a 2-page, very straightforward agreement for £1,000, payable in £200 instalments, and I understand that the first payment has been made. It provides bank details for the payments. And interestingly here, this note says the car has been sold as seen, as agreed, and both the vendor and the seller have signed and dated this agreement. And that's really all that this thing says. The other thing that I've seen is a note which appears to have come from a garage looking at the vehicle, saying that there's a list of things totaling over £500 that need doing to the vehicle. Now, this could be taken a couple of ways. It could either be taken as the garage looking for work, because on an older vehicle there's going to be work that needs doing most often, but it could also be that there is a danger with the vehicle and therefore the vehicle is dangerous. Now, this is where we come into two broad sections to discuss here about these sales between private parties as opposed to traders whose business it is quite literally to sell vehicles. If you are engaging in a private sale, the Consumer Rights Act is not engaged. There are very few rights, in fact, between private sellers and buyers, and in fact there is no onus, generally speaking, on the seller to bring attention of the buyer to defects of the vehicle, which is why it's really important that you have a good look around the vehicle. However, the interesting point here is that a representation made by or on behalf of the seller, if it is a statement of fact which turns out to be false, then that is a misrepresentation, and that is engaged under the Misrepresentation Act of 1967. If there was a statement of fact to the extent that this vehicle is in roadworthy condition, and in fact it is not, and the statement was false, then that would be a misrepresentation by means of which the buyer could rescind the contract because it was a false statement of fact about the vehicle that you were purchasing. Now, this is to be distinguished from things such as this vehicle's great or something of that nature. It has to be a definitive statement of fact, such as this vehicle is roadworthy. However, one other section which might be very useful in cases like this, in buying a second-hand vehicle privately, is section 75 of the Road Traffic Act 1988, because that makes it an offence for any person to sell or offer to sell or to supply or even expose for sale a vehicle or a trailer in an unroadworthy condition. Now, if you remember what I said about the MOT certificate, that MOT certificate was only valid at the time it was issued. Any of you that work in a garage or you issue these MOT certificates, you will know full well that it's valid at the time that you've had the vehicle checked. That's all it really is. It's a certificate to say that the vehicle has been tested and checked at that moment in time and is roadworthy. There might be warning markers on that certificate, there might be things that make it fail. But so long as there's nothing that makes it fail, there might be several warning markers on the MOT certificate, but as long as it passes, that's it for that moment in time. And the legal obligation is obviously to get this done every 12 months. However, as I said earlier, if in the interim something happens, something breaks or just wears out to the point that it's no longer in a roadworthy condition, then it cannot be sold. It's actually an offence to sell or to offer to sell a vehicle in an unroadworthy condition. Now, the interesting bit about this is that it is strict liability, meaning it doesn't matter whether you know that it's in an unroadworthy condition or not. It's an offence regardless. It's also important to note that this section does not just apply to businesses, as many people might think it does. It simply says, subject to the provisions of this section, no person shall supply a motor vehicle or trailer in an unroadworthy condition. So no person shall supply a motor vehicle. So it refers to everybody who is selling an unroadworthy condition. And under subsection 5, it provides that a person who supplies or alters a motor vehicle or trailer in contravention of this section, or causes or permits it to be supplied or altered, is guilty of an offence. So there it is, a very broad definition of what is an offence to provide for sale or even offer for sale a vehicle that is in an unroadworthy condition. On the basis that this may be an unroadworthy vehicle at the time of sale, mind, not way back when it was MOT'd, because as we've just discussed, that was a separate point in time some months ago. If at the moment of sale it was in an unroadworthy condition, and that will be a test on the balance of probabilities, but it will be a question of fact for the court to determine. If it was in an unroadworthy condition at the point of sale, then it would have been a criminal offence for that person to supply it or permit it to be supplied. The best way to determine this would be to get a qualified engineer to do a full safety check of the vehicle to determine whether or not it is in unroadworthy condition. If that report concludes that it is in an unroadworthy condition, then that person was committing an offence by selling the vehicle, and this of course would support a claim for breach of contract on the basis that the vehicle was not as described if it was described as being in roadworthy condition, which is evidenced by the MOT certificate supplied with the vehicle, implying that the vehicle is roadworthy when in fact it was not. And so in summary, the lessons to learn from this are to get the vehicle checked before you agree to purchase it, but if someone does sell a vehicle that is not in roadworthy condition, that is an offence. That will be a good basis upon which to bring a claim for breach of contract in that it was not in roadworthy condition, if that's how it was sold to you. If, on the other hand, it was sold for spares and that was made clear to you, and it was made clear that it was not intended for use on a public road, then not only would that be a defence to the offence under Section 75, but it would also probably scupper your chances for a claim in breach of contract. But that's not the case here. The case here seems to quite clearly have been that it was intended for use on the road and that it was in roadworthy condition. And that's simply by the fact that it was described as being a good car and supplied with the MOT certificate, which suggests that it's in roadworthy condition. So that is but one analysis if those things are true. If it is in an unroadworthy condition, it would have been an offence to make it available to supply. As a complete aside, but probably way beyond the scope of this video, I was also told that the vehicle received a service some weeks before it was sold. This raises the question as to whether that service was any good or whether it even in fact happened. If it did happen, there's a possibility, so long as the owner of the vehicle is specified within the warranty or the contract for the service itself, because obviously that would have been with the previous owner, then there is the potential of the new owner suing the company that did the service under what we refer to of the rights of third parties in contracts. But as I said, this is probably beyond the scope of this video. So there it is, just a reminder that none of this is legal advice and cannot be relied upon as legal advice, because it's just my thoughts based on the limited information that I've been given. But I hope you enjoyed my first sofa chat for these first scenarios to talk to you about. I've certainly enjoyed it because it's much more comfortable to sit here to talk to you about these scenarios, but keep them coming and I'd love to do many more of them. In the meantime, please smash that like button, remember to subscribe, and thank you for watching.